Here's a complete exam-style answer on the topic. Definition of confession and relevancy of confession under Indian Evidence Act 1872. Herfin, definition of confession. The Indian Evidence Act does not define the term confession directly. However, its meaning has been clarified through judicial decisions. Judicial definition: Pakala Narayana Swamy v. Emperor, AR 1939, PC 47. A confession is a statement made by an accused person which either admits in terms the offense or at any rate substantially all the facts which constitute the offense. So, confession equals admission of guilt, partially or fully. Confession versus admission. All confessions are admissions under Section 17, but not all admissions are confessions. Admission equals broader. Confession equals specific to criminal guilt. Relevancy of confession, legal framework. Sections 24 to 30, Indian Evidence Act. 1. Section 24, confession caused by inducement, threat, or promise. If a confession appears to be caused by any inducement, threat, or promise by a person in authority, it is inadmissible. Purpose: prevent forced confessions. 2. Section 25, confession to a police officer. No confession made to a police officer shall be proved against a person accused of any offense. Reason: avoid misuse of power by police. 3. Section 26, confession in police custody. Confession made in police custody is inadmissible unless made in the presence of a magistrate. Only exception: recorded before a magistrate. See Section 164 CRPC. 4. Section 27, discovery of facts. When any fact is discovered in consequence of information received from an accused in custody, so much of such information as relates distinctly to the fact discovered is admissible. Partial admissibility. Discovery statement. Example: accused says, "I hid the knife in the garden," and the knife is found there. The part about the location is admissible. Section 28, confession after removal of threat inducement. If the threat inducement has been removed and confession made voluntarily, it becomes admissible. 6. Section 29, confession not irrelevant due to procedural defects. A confession is not irrelevant merely because it was made under promise of secrecy, made in answer to questions, made when accused was drunk, not formally warned. What matters? Whether it was voluntary and reliable. 7. Section 30, confession of a co-accused. Confession of a co-accused can be considered against another accused only if both are jointly tried and the confession implicates himself and the other. Not a sole basis for conviction, needs corroboration. Important case laws. SNO, case citation principle. 1. Pakala Narayana Swamy v. Emperor, AR 1939 PC 47, defined confession, must admit offense or major part of it. 2. State of UP v. Dioman Upadhyaya, AR 1960 SC 1125, reiterated police confessions inadmissible under Sec 25. 3. Pulukuri Kataya v. King Emperor, AR 1947 P 67, landmark on Sec 27, fact discovered must be linked to confession. 4. Kashmira Singh v. State of MP, AR 1952, SC 159, co-accused confession, Sec 30, needs independent corroboration. Conclusion: confession, being a direct admission of guilt, holds high evidentiary value. However, Indian law emphasizes voluntariness and safeguards against misuse through Sections 24 to 30 of the Indian Evidence Act. If voluntary and legally recorded, confession is admissible and relevant. If obtained by coercion or in police custody without safeguards, it is inadmissible. Would you like a handwritten version, diagrammatic chart, or quick revision note on this as well?